Information in this video should not be considered as a legal opinion in any way whatsoever and does not establish a client-lawyer relationship. This content is not intended to be a substitute for professional legal advice or opinion. Always seek advice from lawyer personally regarding your specific legal issue. If you are new to this channel, request you to subscribe, like, comment and share. Hi, welcome back to GMR Law Associates. Today our topic is whether sale or purchase of property, though sale agreement or general power of attorney or will, is valid or not. This topic is selected, as many of our viewers requested us to make a video in detail about the property transfer through GPA, hence this video for the benefit of the viewers. Please watch the video till the end, so that you will not miss out any important points. Most of the points are explained in and all the way. We will be giving you important tips especially at the end of the video. So watch the video till the end without fail. Let us go on. Many of the subscribers asks me that buying a property on sale GPA would be safe. What is the validity of a GPA or agreement to sale cum GPA or buying of property through GPA cum agreement of sale? Is it legal to buy? There is lot of confusion about the sale of property through GPA. Even today lot of people do transfer the property through GPA and lot of people buy the property through GPA. Today we will understand all those aspects in detail about such as 1. What is power of attorney? 2. What is general power of attorney? 3. What is specific or special power of attorney? 4. When should I execute power of attorney? 5. Can I revoke or cancel power of attorney or general power of attorney or specific or special power of attorney? 6. What are the precautions for preparing power of attorney? 7. Is it valid to transfer of property through agreement to sell? What is the scope of power of attorney? What is the scope of will? 8. Supreme Court on misuse of sale agreement or general power of attorney or will. Whether the transfer of property through GPA is valid? Suraj Lamps case by Supreme Court of India. 9. And conclusion. First of all we need to understand, what is power of attorney, then it would be easy for you to understand about general power of attorney and specific power of attorney. Let us understand. What is the definition of power of attorney? According to the Powers of Attorney Act 1882, it is defined as, power of attorney, includes any instrument empowering a specified person to act for and in the name of the person executing it. That is the definition of power of attorney as per the Act. To make you understand you in more simple terms, a power of attorney is a written document authorizing to act on behalf of other in the general or specified matter or matters. The person making the power of attorney is called principal and the person authorized to act is called as the agent. Let us understand, what is general power of attorney? A general power of attorney authorizes the agent to handle all or multiple acts or affairs on behalf of you in your absence or when you are out of country or when you are sick. These are some of the times when power of attorney is given. The GPA or general power of attorney is very broad, giving the agent broad powers and responsibilities such as 1. Collecting property rents. 2. Tax filings. 3. Managing estates. 4. Entering contracts. 5. Sale of property etc. I hope you have understood the power of attorney and general power of attorney. Now, let us understand, what is special power of attorney? Special power of attorney or specific power of attorney called as SPA gives the agent the authority only for specific act to conduct on behalf of the principal. A good example for lawyers would be the SPA given by the principal to agent for representing in the court. Just to summarize GPA and SPA, general power of attorney is for multiple acts and specific or special power of attorney is for specific act. When the power of attorney is to be executed, or in which circumstances the power of attorney is to be executed. The power of attorney is recommended in some of the scenarios such as, when you want someone to act on your behalf or when you are living in abroad or in your absence some of the acts to be performed or when you are sick or due to any other reason you are unable to do some of the act or acts. The power of attorney does act on behalf of you. Who can be the agent of my power of attorney? Remember, the agent is a person who is going to act on your behalf. It is very important to decide before appointing an agent of power of attorney is that the agent is responsible and trustworthy and will act in your best interests. Ask the following questions to yourself before deciding an agent for your power of attorney. 1. Do I trust this person? 2. Do I believe that the person is trustworthy handling legal and financial affairs on behalf of me? 3. Do I believe that the person is responsible? Remember, whenever you feel that your agent is cheating or you will get cheated or your agent is not trustworthy, you should cancel the power of attorney. Is power of attorney valid after death? Answer would be no. The power of attorney will be automatically revoked after the death of the principal. Question: can I cancel or revoke power of attorney? Yes. You can cancel or revoke the power of attorney. Remember, development agreement cum GPA or GPA with consideration of sale cannot be cancelled unilaterally. The following precautions are must for everyone to consider before executing power of attorney. 1. Execute the power of attorney only when required. 2. Execute the power of attorney only for the purpose specified and avoid executing general power of attorney unless required. 3. Do not forget to put an expiration date in the power of attorney or a condition for revocation or cancellation, whichever is applicable. 4. Get the power of attorney registered, especially if the power of attorney includes the clause of sale of property. 5. Power of attorney executed by NRIs must be attested by embassy abroad and must be validated with the local register. The question is, does sale of property through agreement to sell is valid? Answer. Section 54 of Transfer of Property Act makes it clear that a contract of sale, that is, an agreement of sale, does not, of itself, create any interest in or charge on such property. Transfer of property through agreement to sell is not valid. Let us understand the scope of power of attorney. The power of attorney is creation of an agency whereby the grantor authorizes the grantee to do the acts specified therein, on behalf of grantor, which when executed will be binding on the grantor as if done by him. See Section 1A and Section 2 of the Powers of Attorney Act, 1882. In matter of State of Rajasthan vs. Basant Nahata 2005, Supreme Court held, a grant of power of attorney is essentially governed by Chapter 10 of the Contract Act. By reason of a deed of power of attorney, an agent is formally appointed to act for the principal in one transaction or a series of transactions or to manage the affairs of the principal, generally conferring necessary authority upon another person. A deed of power of attorney is executed by the principal in favor of the agent. The agent derives a right to use his name in all acts, deeds and things done by him, and subject to the limitations contained in the said deed, the same shall be read as if done by the donor. A power of attorney is, as is well known, a document of convenience. Execution of a power of attorney in terms of the provisions of the Contract Act as also the Powers of Attorney Act is valid. A power of attorney, we have noticed hereinbefore, is executed by the principal so as to enable the agent to act on his behalf. Except in cases where power of attorney is coupled with interest, it is revocable. The agent in exercise of his power under such power of attorney only acts in place of the principal, subject of course to the powers granted to him by reason thereof. He cannot use the power of attorney for his own benefit. He acts in a fiduciary capacity. I repeat, the agent cannot use the power of attorney for his own benefit. He acts in fiduciary capacity. An attorney holder may however execute a deed of conveyance in exercise of the power granted under the power of attorney and convey title on behalf of the grantor. Let us understand the scope of will. A will is the testament of the testator. It is a posthumous disposition of the estate of the testator directing distribution of his estate upon his death. It is not a transfer inter vivos. The two essential characteristics of a will are that it is intended to come into effect only after the death of the testator and is revocable at any time during the lifetime of the testator. It is said that so long as the testator is alive, a will is not be worth the paper on which it is written, as the testator can at any time revoke it. Let us look at the Supreme Court observations on misuse of transfer of property through sale agreement or general power of attorney or will deed. By an earlier order dated 15 May 2009 reported in Suraj Lamp and Industries Private Limited versus State of Haryana and others. Humble Supreme Court had referred to the ill effects of what is known as general power of attorney sales, for short GPA sales, or sale agreement or general power of attorney, or will transfers for short SAW, or GPA, or will transfers. Both the descriptions are misnomers, as there cannot be a sale by execution of a power of attorney, nor can there be a transfer by execution of an agreement of sale and a power of attorney and will. As noticed in the earlier order. These kinds of transactions were evolved to avoid prohibitions or conditions regarding certain transfers, to avoid payment of stamp duty and registration charges on deeds of conveyance, to avoid payment of capital gains on transfers, to invest unaccounted money, black money, and to avoid payment of unearned increases due to development authorities on transfer. The similar observations are also made in the later judgment by the Honorable Supreme Court of India in 2011. Let us understand whether sale of property through GPA is valid or not and when. Having understood the in-depth meaning of power of attorney by this time, you would be in a position to judge yourself whether it is valid or not. However, I would like to consider the judgment of the Honorable Supreme Court of India to make it more clear about the subject. Here I will go little bit slow so that you can understand better. In the matter of Suraj Lamp and Industries vs. State of Haryana in the year 2011, the Honorable Supreme Court of India clearly mentioned that, we make it clear that our observations are not intended to in any way affect the validity of sale agreements and powers of attorney executed in genuine transactions. For example, a person may give a power of attorney to his spouse, son, daughter, brother, sister or a relative to manage his affairs or to execute a deed of conveyance. A person may enter into a development agreement with a land developer or builder for developing the land either by forming plots or by constructing apartment buildings, and in that behalf execute an agreement of sale and grant a power of attorney empowering the developer to execute agreements of sale or conveyances in regard to individual plots of land or undivided shares in the land relating to apartments in favor of prospective purchasers. In several states, the execution of such development agreements and powers of attorney are already regulated by law and subjected to specific stamp duty. Our observations regarding sale agreements or general power of attorney or will, are not intended to apply to such bona fide or genuine transactions. Let us come to conclusion. Transfer of property through not valid by means of sale agreement or will deed, but transfer of property is valid if it is genuine, prepared according to law, properly stamped and registered. Thank you for watching the video. If you have not yet subscribed this channel, liked, commented and shared this video. Please subscribe this channel, like, comment and share this video now.